So you said you had like an hour and a half per side. Do you actually present evidence, or you just summarize what the evidence is? Is there a testimony? I've never done one of these, so I'm kind of curious how it works.
There aren't any rules. It's an interesting process. So when we were talking about just the summary jury trial with Judge Dean beforehand, and this was before we were even ordered to do it by Zoom, he said, each side has an hour and a half, and you can put on your case any way you want to. You can call live witnesses. You can do it as kind of a extended closing argument, whatever you want. Each side gets an hour and a half, and the other side can't object. So you can do just about anything you want. And then as the plaintiff, I decided I wanted to do an hour and 20 minutes and save 10 minutes for rebuttal. But I put on my case for the hour and 20 minutes. The defense puts on theirs for an hour and a half. I get my 10 minutes, and then you have a verdict form for the jury to answer. It's not the same as a typical verdict form that you would give in a trial, but it's similar, just in a abbreviated format, hoping that they will deliberate and get you an answer quicker. So when we were ordered to do this by Zoom, I started thinking, okay, how do I want to present this? And I just decided, from my perspective, I want to try it like I would for a regular jury trial. So I did about a 10-minute opening with a PowerPoint. I then called my client to testify, and then I called my key expert to testify for about 30 to 40 minutes. And then by the time that was all done, I had saved about 10 minutes for rebuttal, which I used as a rebuttal / closing argument. So that's how I put on my case. The defense lawyer on the other side, she did it more like a extended closing, where she had a PowerPoint put together and she spoke for her hour and a half, but she would weave in some deposition testimony, some exhibits that had been, or some discovery that had been exchanged between the parties. So that's how the case was presented to the jury.
Have you done other summary jury trials before?
Nope, this was my first time.
Well, you've done one more than I have. Looking back, I mean, do you think there's an advantage over one approach, which is yours, of actually putting on witnesses, versus the defense approach, which is doing, I guess, what they call a big opening or closing opening together, where you're arguing, you're presenting evidence, but you're not doing the question and answer thing?
Well, and I've thought about that a lot. And I think if I was asked to do this again, or had the opportunity to do it again, I would do it the same way I did it. I might modify things a little bit, but the whole idea of doing a summary jury trial is to get the evidence in front of the jury and get some real world feedback about the strengths and weaknesses of your case. And so, you hope that you get the feedback and the verdict that helps get your case settled and maximizes the recovery for your client. But if the case doesn't resolve, you have some feedback, kind of like you would do for a mock jury, that you can help hone your case, your witnesses, your presentation of evidence, so that when you do go to trial, hopefully you have an even tighter and better and stronger case.
Yeah, as much as I like to control everything, and I think that I would present well, I would think that from a credibility standpoint, having someone other than the lawyer speaking would be more persuasive, just because we walk into a courtroom with so little trust and credibility at the start, as opposed to a client who may have a little bit more. I think just hearing from witnesses would probably help. Although I don't know, I've never done it, but that would be my thought.
Well, and so the good part about it too is, once you get the result back from the jury, you have an opportunity to ask them questions. And so the thing that I wanted to know, and I asked, is, what did you think about my client? I put on my expert. Could you follow my expert's testimony? Was he credible to you? So those are the type of things that, you want to know when you go to trial. And so that's where I think, if you just do a closing argument and, you present the evidence, and it may not actually be admissible evidence, but you present the case and you think the ultimate best way it is, I don't think you're getting good feedback about, what a jury might decide if and when you go to trial.